Good morning, all of you, and welcome to the daily news analysis of 15th December 2023. As usual, today we are doing the analysis of yesterday's news analysis. I hope that all of you are doing well. One more
Good
thing.
morning, all of you, and welcome to the.
After finishing the analysis of this news, you can take an examination in the description link of yesterday's news. Every day, we will prepare the detailed news analysis for you. We will give you the PDF of the detailed news analysis in the description of this video. I will take a class in the morning, and the live YouTube video I will take in the morning, explaining the most important topics of the previous day, the yesterday's The Hindu newspaper. After watching the class, you can get a link in the description. Using that link, you can take a live examination of the daily current affairs. From the yesterday's current affairs, how far you have studied and how far you understood the topics, you can take a prelims model examination as well. This pattern of making detailed news analysis PDF, detailed news analysis video, and the daily news analysis examination will definitely help you in clearing your current affairs and in studying the current events. That is one of the most important part of the civil services examination, whether you are preparing for UPSC or any other state civil services examination. Let us start the first topic of today. The first topic of today is related to Satluj Yamuna linking canal. It is a long-standing project, and the inauguration or the opening or the starting of the construction work, the foundation stone for this Satluj Yamuna link canal has been laid by Prime Minister Indira Gandhi on April 8, 1982. That means a pending project for a long period. Mainly, why it is pending? Due to the dispute between Haryana and Punjab. This dispute started after the formation of Haryana, or this bifurcation of the state of Punjab into two, Punjab and Haryana. After that was a demand of Haryana, they should also be shared the water of Satluj River. For sharing the water of Satluj River, a 214-kilometer long canal project was proposed. As I mentioned earlier, in 1982, Prime Minister Indira Gandhi launched the construction or laid the foundation funds for this canal, and in a program organized at Kapuri village in the Patiala district. A stretch of 214 kilometers was to be constructed, and out of which 122 kilometers was to cross Punjab and 92 kilometers in Haryana. Mainly, this project is not moving ahead due to the objection of Punjab state to this project. Punjab does not want to share the water of river Ravi and Bias. The canal, once completed, will enable sharing the waters of the rivers Ravi and Bias between the two states of Punjab and Haryana. It was a part of agreement when the bifurcation of Punjab was done and Haryana was formed out of Punjab. Now, in the bifurcation and when we divided the two states, the decision to share the resources was taken, and the terms of sharing the waters of the two rivers, Ravi and Bias, were left undecided. Haryana is demanding that for their agricultural development, getting the waters from Ravi and Bias through the Satluj Yamuna link canal is required, but Punjab is opposing sharing the water and construction of this project. That is why this project is pending for quite long time. You can see the map of the rivers, the Indus River system and the tributaries of Indus and how it is flowing. It will help you to understand and how this dispute arises. Next topic we are discussing is there was a breach of security in the parliament. In the breach of security in the parliament, the most important thing for our exam point of view, and the case has been filed in this matter under Unlawful Activities Prevention Act, the UAPA Act. We need to understand what is the UAPA Act passed in by Parliament of India in 1967. Multiple times we have made amendments to the UAPA Act. After 2008 terror attack in Mumbai, when Ajmal Kasab and the team from Pakistan attacked the Mumbai city, immediately Parliament of India made certain amendments into the UAPA Act to make strict action against any action of terrorism in the country. In 2019 also, Parliament of India made certain amendments to the UAPA Act in the year 2019 as well. For our exam point of view, from this news, we have to study in detail regarding the Unlawful Activities Prevention Act, UAPA, and that wants to mainly UAPA intends to take strict action against any action which is a threat to the India's sovereignty and integrity. Definitely making a attack on Parliament of India, even if it's not a violent attack, but making a breach of security inside the Parliament of India is a threat for India's sovereignty and security. It was originally passed by Parliament of India in the year 1967 to deal with anti-national activities and secessionist movements. The law was amended multiple times, as I told you. After 2008 terrorism attack on Mumbai, it was amended. Most recently, it was amended in 2019 to include the provisions related to cyber terrorism, terrorist financing, and seizure of the property of the people who are involved in any such terrorism financing or cyber terrorism. For these reasons, this act was amended in 2019. Definitely. And there is a special procedure in the act to deal with terrorist activities. The act is one of the scheduled offenses of that NIA deals. National Investigation Agency, NIA, National Investigation Agency was a new organization of Indian investigative authorities. They are expert and trained in investigating the terrorism activities. NIA, National Investigation Agency, was established in the year 2008 and by NIA Act 2008. The reason was the terrorist attack on November 26, terrorism attack in Mumbai city has ignited and has made the situation to establish and to form a new investigating organization named as NIA. NIA and has certain offenses that NIA will investigate. The offenses which are categorized under UAPA are the scheduled offenses for the investigation of the NIA. For example, other offenses that NIA scheduled for NIA are Explosive Substances Act, Atomic Energy Act, Anti-Hijacking Act, and the Information Technology Act. The offenses or the criminal offenses coming under these acts will be investigated by NIA, National Investigation Agency. NIA has a power case sumoto. That is, without getting any complaint from anybody, and even if a news comes in the newspaper or by getting some information from any source, without getting any written official complaint, they can file the case themselves in the terror activities, and they can enter any state without permission of the state government. If there is an information that some terrorist is hiding inside a state, without informing the state police, NIA can enter the state and arrest the person involved in the activities. NIA investigate cases of human trafficking, counterfeit currency, the fake currency, cyber terrorism, and the offenses coming under the Explosive Substances Act. The 2019 amendment to the NIA Act. NIA Act was also amended in 2019. The 2019 amendment of the NIA Act has given a very unique and special power for NIA. That is, NIA can investigate, can prosecute offenses committed outside the country. That is very important in the recent issues of some conspiracy happening against the country in Canada. And then if an offense is committed and that is a terrorism offense or an offense against the country, if the offense even it is committed outside India, as per the Indian law NIA Act, National Investigating Agency can investigate the case. Next one. Another important news from today's The Hindu is Allahabad High Court allows survey of Madura's Shahi Eidgah Mosque. Before moving to this news, let me repeat once again. After this class, going to the description of this live video, you can take the daily current affairs examination, because I told in the beginning that time the number of live people were less. Now some few people are there. And for your information, every day, please attend the live session. And this will be definitely, I am focusing only on the very limited and selected news that is highly relevant for our civil services examination, whether it is the state civil services or it is the Union Public Service Commission civil services. That is why you can share with your friends. If possible, you can put the live link on your status and let maximum number of people watch the live video. And I think that for the current affairs, mostly the recorded videos are coming, but a daily live class, I'm trying to do myself best in bringing the daily every day, and the time we will confirm and finalize and inform you for a fixed time every day. I will come in front of you live and I will explain you within 15 to 20 minutes the most important current events. Allahabad High Court allows survey of Madura's Shahi Eidgah Mosque. This is a dispute. Shahi Eidgah Mosque was constructed by Aurangzeb, and the dispute is that close to Shahi Eidgah Mosque there is Madura's Krishna temple, where Krishna is believed to have born. Then the dispute is that Aurangzeb has constructed this Shahi Eidgah Mosque after demolishing an existing temple on that particular land. Here, what is the Indian law related to such disputes? The first one is that we have an act passed by the Parliament, the Places of Worship Act 1991. The Places of Worship Act 1991, it was made in the controversy of Babari Masjid and Ram Janmabhoomi dispute. Now, the Places of Worship 1991 Act tells that, and that tells that all the status of the places of worship will be frozen based on its status on August 15, 1947. That means the place of worship of one religion cannot be converted into the place of worship of another religion. We will freeze it. We are freezing the status of the all places of worship based on whatever was the status on August 15, 1947. This act was passed to prevent any future dispute and clash and violence among the people of India, claiming that this place of worship is belonging to this religion. In the long back history, medieval history or ancient history, it has been taken over by another religion. To make an end to that dispute, Parliament passed the Places of Worship Act 1991. The act tells that no person shall convert any place of worship of any religious denomination into one of a different denomination or a section. Again, it prohibits any legal proceedings from being instituted regarding the character of a place of worship. Whatever is the character of the place of worship, in August 15, 1947, questioning that no legal proceeding can be instituted, but there are certain exemptions. This case is not applicable for everything. There are certain exemptions. The 1991 Act will not apply in some cases. It will not apply to ancient and historical monuments and archaeological sites that are covered under Ancient Monuments and Archaeological Sites and Remains Act 1958. If a site is coming under Ancient Monuments and Archaeological Sites and Remains Act 1958, this law is not applicable. The 1991 Act is not applicable to that particular place. That can be converted from one religious denomination into another one. Next one, it will also not apply to any suit that has been finally settled. If any judgment already has been given by the Supreme Court or High Court and it has been decided earlier, before 1991, if any dispute has been settled by a court, this act will not be applicable. Again, it mentioned that this act is not applicable to the dispute of Ram Janmabhoomi and Babari Masjid in Ayodhya. Here, because the already suit was going on, then the act wanted the Honorable Supreme Court of India to make a final decision or let the dispute be settled out of the court was the vision of 1991 Act. Then 1991 Act, why you might have a doubt when I described the 1991 Act, then why the Babari Masjid issue the case was going on, because the case was already pending in the court. Then the Act has exempted Ram Janmabhoomi and Babari Masjid dispute of Ayodhya. Now, going back to the history, what is Shahi Eidgah Mosque and another Krishna Janmabhoomi temple in Mathura? These are the two adjacent historic monuments. Shahi Eidgah Mosque, located in Mathura, Uttar Pradesh, and it is said to have been built in 1670 by Aurangzeb on the site of an earlier temple. According to the Hindu petitioners given, the mosque was built after demolishing the temple on the orders of Aurangzeb is the case. The area was previously owned by Marathas and the British and was considered as a non-agricultural state land. The land where the dispute is there at present, it was considered as a non-agricultural state land before independence. And local court in Madura has ordered a survey of the mosque by the Archaeological Survey of India after January 2, 2022, the local court asked to do a survey, and the main suit and seeks to the removal of the mosque on the ground that was built on the Krishna Janmabhoomi land was the petition filed by the temple authorities. And now coming to the Sri Krishna Janmabhoomi temple in Mathura is a pilgrimage site and one of the most visited religious destinations in India. And it is believed that Lord Krishna is said to have been born here. The temple is believed to have been constructed 5,000 years ago by Vajranbha, and the great-grandson of Lord Krishna is the belief. The site has been religiously significant and at least the 6th century BC, and with excavations uncovering the religious artifacts belonging to the 6th century and before Christ. However, the temples have been destroyed multiple times, and the most recently it is believed that during the empire of Aurangzeb, it was destroyed and a new Shahi Eidgah mosque was constructed. The last news we are discussing today is delisting parties with religious names. Only House can decide. A party, because in India, asking vote in the name of religion is prohibited. And by the Representation of People's Act 1951, and no political party can ask the vote in the name of religion. Then a political party in the name of religion, can it be delisted or de-recognized? The Delhi High Court has mentioned that this decision can only be taken by an act of parliament, whether a political party in India can function with the religious name, the name of religion. Deregistration of political parties and deregistration of the political parties, Election Commission has the power to register a political party. Under Representation of People's Act 1951, the authority to register a political party is Election Commission. But as per Representation of People's Act 1951, Election Commission does not have the power to deregister the party. See, power to register the parties for Election Commission, if in the examination, if a question comes then, Election Commission of India has the power to register as well as deregister a political party. And that is not correct, because election commission has the power to register a political party, not to register. At the same time, election commission, the term, you have to understand the difference between the term deregister. Deregister means an active political party and canceling their registration. There is another term, and another term, delisting. A political party was listed as a state party and removing the status of their state party and delisting the party. Delisting means removing the parties from the list of recognized political parties. That power is there for election commission. Listen to me carefully. If a statement comes in this way, election commission has the power to do the registration of political party, and again election commission has the power to do the delisting of political party. That is correct. But if it is deregister and that statement is wrong, election commission does not have the power to deregister a political party. While deregistering means completely canceling the registration, delisting normally, if a party was registered, later the party became completely inactive party. The party is not functioning, and only if the name is there, no workers, no party, the party is functioning, then removing the party from the list of recognized party is the power of election commission. Election commission only can refer the matter of deregistration to the central government for further action. The distinction is important because, and if election commission is going to deregister the parties, and the party will no longer exist as a legal entity, that much power election commission cannot be given. Commission can be given only the power to delist a political party. Then these are the important news for today, and today means from yesterday's newspaper. And once again, I'm requesting you all, please take the examination in the description link, and you can download the PDF of the detailed news analysis in the PDF. And we have included certain news from Indian Express also. We have included certain news from an Indian Express and other newspapers as well. Then I request you all, and please take the examination. And once again, I thank you all for listening to me today. Please come tomorrow. You can share with your friends. And I'm happy. And if you are able to contribute in increasing the number of the live students in the class, the free platform, that is what I'm doing in the YouTube, and you can share with your friends, and you can bring your serious aspirants, the friends who are serious aspirants, into our daily session of the current affairs. Thank you all. We'll meet again tomorrow. Have a great day ahead.